The proceeding.
Before we start, can I just check if everybody's relaxed about us referring to you as by your first names? Yeah, thank you. Okay. Order. Good afternoon and welcome to this afternoon's evidence session of the Women and Equalities Select Committee and our inquiry into the escalation of violence against women and girls. This afternoon we have Laura Farris, the Parliamentary Under Secretary of State for Victims and Safeguarding, Charlotte Breen, who's the Interim Deputy Director for the Interpersonal Abuse Unit at the Home Office, and Amy Randall, Director of the Victims, Vulnerabilities and Criminal Law Policy Directorate at the Ministry of Justice. Thank you very much for attending this afternoon and the evidence that you're about to give us. I'm going to start off with some questions around data collection and how the government is collecting data on escalation of crimes and what is being done to best understand what perpetrators may be doing and how the nature of their crimes may change and increase. Minister.
Well, I think that's a very good question and a very good starting point. I think that data collection isn't good enough, and I think some of that is linked to the fact that offences are not always accurately recorded in the first place. But let me tell you what I do think about data that we've learned principally in the period that predates me becoming a minister. I think we've learnt that stalking is an important indicator of future violence against women. We already have some data that shows that 50% of those who commit an offence of stalking will re-offend, but we've got more powerful data than that, which shows that female victims, female homicide victims, very often have a stalking background that leads up to the homicide itself. So we know that there's a connection. Another really important finding came out of Claire Wade's review into domestic homicide that you'll recall was published last year and has been quite an important focal point actually for the Criminal Justice Bill and other legislation, where we've recommended, I think, 8 out of her 12 overall recommendations. And she found that, she said something which I think we half knew as a parliament, but I think has really embedded now, that coercive control underpins pretty much all domestic abuse, and also coercive control has a strong nexus with domestic homicide. And then I think the thing that we've learnt about most recently are things like indecent exposure, what we might call exhibitionist offences. It isn't just confined to indecent exposure, although obviously that's particularly resonant at the moment, but other forms of exhibitionist offence. There's about a 10% connection with a exhibitionist offence and some form of further offending. And then something else that I think is important data that I've learned from Professor Catherine Hall, who the government's recently appointed as the independent advisor on the rape review. And that is that if smaller offences go unchecked and don't result in police intervention or a conviction, it isn't just enough to say, well, will this offence lead to something more serious? The very fact that it goes unchecked can lead to an escalation, with the perpetrator sometimes believing that they haven't really done anything wrong because nothing happened, and sort of telling themselves that it's permissible behaviour, which can lead to an escalation. We also know that if there's an increased frequency between low-level offending, that's a strong predictor of going on to something more serious. And I think the other thing that has been suggested is that, I think really the point around the police not addressing it is emboldening for people to go on to more serious offences. So I think we do have some important data now to work with, but I would like to be in a position where the data was better.
And what are you doing to improve it?
Most of this has come through the conversations we have with the College of Policing and the way that they gather data and the way that we expect them to respond to this. But I think one of the things that we have been looking at very seriously is the way that MAPA management and the sex offenders register is working, because that is the way that government, I suppose, has the greatest opportunity to influence the management of the most serious offenders. Of the people in this country who are under MAPA management, and you'll recall that that is reserved for the most serious offenders, so that's sex offenders, serious violent offenders and terrorists, there are approximately 91,000 people who are managed by MAPA, and of those 68,000 are on the sex offenders register, so by far the biggest proportion of people managed under MAPA are serious sex offenders. One of the things that we do know is that the reoffending rate, when you come to very serious offences, so homicide, a serious sexual offence, is low. For example, in the last year, it was something like 124 people out of 91,000 went on to commit a serious sexual offence. It's 0.1%. We also know that the number of people who are MAPA managed who go on to commit another serious offence has fallen and is falling sharply since about 2018 when we last gathered the data. So it was about 242 out of about the same cohort 6 or 7 years ago. It's now fallen by about a third to 150, 160. So we do know that intense management after the person has left prison is very helpful for stopping serious offending from continuing. But on the low level offending, there are two issues which I think are really important. First of all, that the police are recording those crimes correctly. And in fact, one of the reasons, just to give you a slightly different example of what I would call a gateway offence, one of the reasons why we're putting spiking as a distinct offence onto the statute book is because it was inherently undesirable to be wrapping it up under either poisoning under the Offences Against the Person Act or date rape under the Sexual Offences Act, because you could have pretty much the same offence being recorded in different ways by the police forces, which of the 43 police forces it was, so that the police don't have an accurate picture of actually what's going on. If you have a spiking offence, then you're bringing it all together and building a better data picture of what's going on. And in addition to that, just as important is the spiking reporting tool, which people can use anonymously. They can use if they haven't been a victim of spiking, but if they've been in a bar where they think there was something they saw somebody doing something very suspicious looking. So you can build more of a data picture, even if there hasn't been police intervention, of what's been going on. Now, that's just one example of one offence, but actually accurate police recording is really, really important part of this so that we can continue to build the data set.
And what's been done? I think your opening comment was that offences are not recorded accurately. So what's being done specifically to make sure that those 43 police forces are recording offences accurately?
Well, one of the things that we've done, which is, it's actually a return to a pre-existing model of crime recording, but it is new in the sense that it was only brought in this year, is that in 2017, I think, the police moved from a model where they would record the principal crime and record sub-crimes underneath to recording every single crime on their system. And what we had found is, and this is from conversations with the policing minister, as well as officials actually who I will bring in a moment, is that two things, in fact. When they were required to record each crime separately, there was scant detail sometimes being applied to each crime. So they weren't accurately, thematically recording what was going on. And secondly, they were saying that it was creating an administrative burden. The way that we've returned to the principal crime reporting rule is actually intended to get the police to record courses of conduct behaviour more accurately, so that you'd get the principal crime recorded as coercive control, and the sub-crimes within that might be criminal damage, a malicious communications offence, an economic abuse type matter. All of that would fall actually under the umbrella of coercive control. Equally, stalking might have a malicious communications element that would be common with a stalking offence. So the idea is now that we're going back to a model where we should be recording course of conduct behaviour better. Another point that's been made by the independent advisor to the rape review, which I think is really important, and I've relayed this to the policing minister and he's in agreement, but I have to say this conversation happened in February, so we're still at an early stage, is that she was saying that one of the things that's really, really important in the recording of rape is capturing the most accurate detail. And she says too often she's encountered, when she's been around different forces, that they're recording irrelevant detail. For example, mode of attack, he sort of came up from behind, which is not really ever used by the police again. And they're missing critical details, like, for example, the nature of the relationship between the perpetrator and the victim. The ethnicity of the victim and the perpetrator, the age of the victim and the perpetrator, critical details. And she has asked that we have a renewed focus on data analytics that slightly takes that responsibility out of the hands of the everyday police officer and improves the drive to consistency of data gathering in relation to serious sexual offences. And that's a conversation I started with the policing minister.
Can I go back to your comments about MAPA management, which is only for the most serious offenders, the ones who have been charged and convicted of serious offences? So we've got 91,000 of them with a low level of reoffending. I think we'll all agree that, because they're very intensely managed. What confidence do you have that those who are not yet committing the most serious offences are in any way being managed to prevent them from continuing on that offender journey?
That's a very good question. I think there's one thing I can say which should give you some confidence, and another thing in which I'd like to see some improvement. So the first thing is that MAPA category 3, which is a lower level category, is for people who are convicted of domestic abuse or stalking offences, and that has expanded quite significantly recently. And I think the most recent data I had was that was something under 1,000 people who were on that, but they were people who obviously had been convicted of an offence that you wouldn't historically link to serious sexual offending or terrorism, but nonetheless they were managed under MAPA. And I think that's a good that's good positive progress that we're seeing. In other words, a more creative and imaginative use of MAPA, albeit in a different category. So that's to give you some encouragement. One of the things I think that is important actually, where I think there is a little bit of disparity in the way police forces are using them, are in relation to their safeguarding powers. So for example, where you have somebody who goes to the police reporting an offence and then they decide they don't wish to continue in the criminal justice process. The police still retain powers, for example, to make a stalking prevention order or to make a sexual risk order, which are civil orders. They can get them in the MAGS court, so very little delay, straight in and get them. And if the perpetrator breaches that order, then the maximum sentence they can get is 5 years. That's a powerful tool, actually, that allows the police to set terms and restrictions on somebody's behaviour, even if they're not about to go through the criminal justice system on a big trial. And I think that safeguarding element is really, really important. And I would like to see more consistency in the way those orders are being used. Because actually, if you think about it, if somebody ends up breaching an order and getting 5 years, that's very much comparable with what they might get for the index offence anyway, and is a really important tool available. And one of the things actually that I've been thinking about in relation to this is just no more than a thought I've had, is whether or not the range of orders that we have and all the different titles that they have is in some way confusing, and whether or not we should just have a general protective order that the police could apply for and then say, because this is a case of stalking, and then put in all the normal things that you'd have with a stalking prevention order. Or we need a sexual risk order because this person, we know this person, we've heard about them more than once, we think we should be putting these prohibitions. But what they're seeking is a protective order, so that it's less of a kind of complex web of different orders they need to be thinking about, and they can simply think about a simple order that's much easier for them to go for. That's something that I've been mulling. I don't know, I haven't really worked through, but just to almost make it more accessible, more user-friendly, to see more consistency in the terms of public protection.
A preventative order presumably would act as a significant deterrent to somebody who had not yet become a serious perpetrator.
One of the things we do know, and you get this when you talk to any force, is that there are a small number of perpetrators who cause the most amount of harm because they repeat. And that is where there are individuals who will be known to not just the overall force, but will be known in a locality, and where you could apply safeguarding provisions which don't require them to have a criminal conviction, don't require the whole Crown Court process, but do involve the police saying, we've heard about this person in more than one context, on more than one occasion, we think it's appropriate to, say, impose a sexual risk order. And then if they breach that, you immediately have teeth and you get them straight into custody, potentially.
What are the delays in the magistrate system that might hamper that?
The delays in the magistrate system are very close to being back to pre-pandemic levels. It is the delays in the Crown Court that are more substantial.
Okay. And you'll be as painfully aware as I am of the horrific incidents we've had within the emergency services of perpetrators, and we've taken evidence as part of this inquiry about really abhorrent behaviours in the emergency services. What are we yet in a place where we can say that everything possible is being done to prevent perpetrators from being employed within our blue light services.
I think some of the things that have happened in the last few years have, I think they have shaken parliamentarians, I think they've shaken society to its core. And I think that there has been a lot of work that's been done, and I can touch on a bit of it, but I think there's further to go, and I can say what I think that looks like. I think there has been a fundamental rethink about police vetting, about the frequency and stringency of that vetting. I think the College of Policing have done a lot of good work on that. I think we're getting to a much better place on dismissal. And I think it would be news to many people, including to me when I first discovered it, that before Dame Louise Casey wrote her report into the Metropolitan Police and we sort of uncovered a lot, it wasn't automatically the case that an officer who'd been found to have done an act of gross misconduct wouldn't automatically be dismissed. Now we're getting to that point. We've got to that point. But that wasn't the case before. And I think we're giving chief constables more power through things like the Criminal Justice Bill. So if one of their officers goes through a disciplinary and is exonerated, if they don't agree with that, they can now appeal, which is completely irregular. That doesn't exist in any other employment law scenario where the boss can basically say, I'm sorry, this one needs to be looked at again because I'm worried about this officer. I think that's a good thing.
Is there any evidence that chief constables are using that power?
Well, first of all, that power is in the Criminal Justice Bill, so it's nascent. But we do talk to chief constables, and we are very interested, actually, in whether or not they have enough power at the moment, because nobody's closer to it. Nobody knows what happens more in an individual organisation than the person at the top, and they are the ones who are responsible for leadership and culture. But it's on these themes of leadership and culture that I'd like to come back to you a bit. And I think that when you look at, I'll use the broad headline of the blue light services. When you look at any workplace where there is a persistent problem of misogyny, that is a question of workplace culture. And the culture is set from the top. And I do think that engages really big questions about the overall cultures that have been permitted. And the other thing that I think is relevant is diversity in some of those workplaces, and even within individual units of the workplace. And I think it really matters when you have, this is not an attack on men, but when you have a completely male-dominated environment, particularly when you're doing what one might say are historically sort of more macho tasks. I think that is something that can be helpfully countered by a more diverse workplace. And I don't think anybody on this committee needs me to explain why diversity matters, because that's your inherent work. And the other thing, I think, just stepping back and talking about violence against women, and I was thinking about this when I was preparing for it, everybody who is really deeply engaged in the issue of violence against women tends to be a woman. The minister today, the civil servant sitting next to me, the perpetrator programmes you heard from Respect and you heard from Safe Lives, you heard from Refuge and Women's Aid. If you went into, who is the National Police Chief Lead, Dame Maggie Blythe? Who are the people who are pioneering Operation Soteria and Rape? It's female officers. So you have this across the spectrum, the people who are most actively engaged in dealing with violence against women, male violence against women, are women. And I do think, actually, something that would be hugely beneficial for society is to make this a more diverse exercise in itself. Not to to always be women sort of thinking about this issue and deciding what to do, but having at the top, in the decision-making roles, men embedded in dealing with male violence against women.
Stuart Cundy, who we heard from, made it very clear that it was unexpected that he took that job, that he applied for that job. We hear this all the way through. All the way through. If I'm dealing with anybody, whether they're operational or whether they're in policy, or whether they're an academic with this expertise, whether it's Jane Monckton-Smith or Professor Catherine Hall, who I mentioned, these are always women who are looking at this issue. And I can't think of any other category of offence, specific category of serious offence, which is totally, where sort of women are expected to answer the question. And that, as I say, that isn't an attack on men. That's not an attack on men. I really want to make that clear.
but it isn't a diverse area of the law and the way we think about it. And look at who's attended the select committee today. It's female politicians. And I don't mean this critically. It's a reality. And I'd like to see this whole area being better staffed and better engaged with by men and women.
Thank you. Kirsten.
Thank you, Chair. I just wanted to go back to something you said a minute or two ago. You were talking about the police, about workplace culture being set from the top. I'm sure you'll be aware that in the statement about the Angelini inquiry, the Home Secretary talked about automated systems being brought into place to try and move things along in the Metropolitan Police. And I wonder if you are any clearer than I am on what that means. What is an automated system? How might it work to protect against these kinds of crime? And how particularly might we prevent that workplace culture from putting a bias that already exists into the heart of some kind of AI or similar system?
That's a really good question. So I think that there is a really big opportunity for AI to resolve some of the issues that the Chair's just been asking me about. And I've talked about, for example, inaccuracy in crime recording, or at least inconsistency in crime recording, and also about the crucial importance of data that we know really matters to some of the most serious offences, and building an accurate picture of what leads where. And one of the things that's happening at the moment is, you may have heard that the Avon and Somerset Police, they've been in the spotlight recently because they were the pioneering force that piloted and then sort of almost have led nationally on Operation Soteria, which has had has led a radical improvement in the prosecution of rape. One of the things that they're doing at the moment is a kind of a rape data audit, where they are joining up with the CPS and the court system and looking at every offender who's been reported to them, perhaps all their previous, how that case came to be reported, did they send the case file to the CPS, did the victim withdraw at a later stage, if so when, what reason was given, what did the CPS do with the data, how did it end up in the court system. And they've been doing a sort of historic review of cases between 2016 and 2020 and are building this really impressive data set that you might think should be available anyway and would be helpful in all crimes, all serious crimes. And in fact, it's something they're doing manually, and it's a pilot, and we're learning lessons. And it seems to me that that would be a natural space where AI could step in. If you could have a good computer system that could straddle those three services, for example, be building a picture. I've told you where I think sometimes data's not recorded, that's or irrelevant data's captured, relevant data isn't. So that you could have a situation where either the MPCC or the College of Policing were designing a database with all the stuff that they really want to capture, using a computerised model to do it, and then building databases that could run across policing, the CPS and the court service and build a much more accurate picture. I don't know if that's what the Home Secretary was referring to, but that's certainly something that I wouldn't be surprised if he was, because I think that's really helpful. Now, that doesn't remove, by the way, the human element of policing. But I think it does take out something that some officers would say was bureaucratic, kept them in the station, meant they weren't doing their jobs, but actually is really critical. And so I think there is a massive opportunity, if AI was used right, to capture much more than we do and for it to become habitual and to be able to build much better data patterns that would help. But no, that doesn't resolve, of course, the human element of policing or the cultural issues that I was referring to in my answer before.
Thank you. I mean, my concerns were particularly about the internal issues, although the external points you make are relevant as well. So, perhaps we'll hear more of that as we go on.
Yeah, thank you. So, look, I always hold up Avon and Somerset as the shining example. And from your earlier answer, you don't think that that's any coincidence that Avon and Somerset is led by Sarah Crewe, female chief constable. What is being done to make sure that male chief constables in other forces are watching what's happening in Avon Somerset and learning from it?
Well, okay, so that is a really good question, and Sarah Crewe is exceptional, and I really enjoyed meeting her. And one of the things that is now irrefutably true is that Operation Soteria, which is no longer just located in Avon and Somerset, but has been rolled out nationally, we call it the National Operating Model, across all 43 forces has completely transformed rape prosecutions. If you look at the 5 Pathfinder forces, Avon and Somerset was the first, but there were 4 others. Those forces are referring to the CPS something like, some of them as much as quadruple the number of cases that they were sending to the CPS before. And it's also done something else, which sounds quite boring, but is actually critical, which is it's meant that the CPS and the police are working together much better at a very early stage. Do you recall that the Centre for Women's Justice submitted a super complaint against the CPS, and they said, you're just sending to court rape cases that you know you're going to win, and they challenged that. Well, actually, I'm not commenting on that, and I don't think that they succeeded in that. But the argument was, obviously a very powerful one. And one of the things I definitely think you're doing is seeing the CPS and the police working in tandem to take cases with a much stronger confidence in the jury and allowing them to hear the evidence and reach a decision. And so Operation Soteria has been highly, highly successful. One of the things that we're doing in government is taking steps now to ensure that it embeds. So it's not just something that this government now is very focused on and then it loses traction in 2 or 3 years' time once we feel that rape prosecutions have returned to an acceptable level. I think it's something that needs huge focus, probably for the next 5 to 10 years until it is completely normalised across all forces. And I think it's a fair challenge to say, well, it's all very well having the star performers, but what do you do about the underperformer who's a late adopter? The other thing I think that's been important, which complements this, is you probably are aware there are 2,000 officers who will now all be in place by April, who've been distributed on a pro rata basis across the 43 forces who've had specialist rape training. And I want to make clear the training they've had is a sort of an initial amount of training. It's sort of 3 or 6 months of specialist rape training. But that is Operation Soteria training. And it was quite unusually delivered in that it was the Operation Soteria academics who designed that training. That's quite unusual. Normally the College of Policing would have done it autonomously, but it was very much done in conjunction with Soteria. So those 2,000 officers have got that specialist training and are in post to do that work. And I think that is really, really encouraging. And it was just sort of interesting hearing quite anecdotal material about how an officer what an officer who'd undergone that training would know and understand and change in their approach. So, for example, some of it was really, really simple stuff, but just, I'll just give you one example that I heard, which is really simple. That previously a police officer would have seen all working hours perhaps as appropriate to contact a victim if they were following up on the case or getting them in for something, but not taking into consideration that that person had young children and from 3 o'clock would be picking up from school and would not be in a position to discuss a crime that had been as violating as rape because of who was in the room. Things like that. Much more focused link up with ISVAs, independent sexual violence advisors, who victims often feel a lot of confidence in because they're not police officers and they're not lawyers and they're not anybody who's, in an official capacity. They are, in the truest sense of the word, litigation friends who will hold your hand and support you, and being willing to work through an ISVA if that was appropriate. If the ISVA said, well, look, we need a bit of time out on this, or we want to keep going with this, having a spokesperson and the police having a good and healthy symbiotic relationship with those people. That's just a small example. But I wasn't, and also, of course, the investigation model, knowing how to approach the investigation. And one of the things I've heard from a trained officer, which again I thought was really, I didn't know this, is that if, for example, it was a date rape in the context of somebody who'd been on a dating website and that had been the perpetrator, knowing that you could begin that conversation with the internet, company, the dating company, that they would be often are constructive in allowing you to look at the perpetrator's account, the way you might look at the way they'd approached other people, was there a common mode of practice, things like that, being able to build a data picture that was much more accurate, much more quickly about the way they'd behaved, how they'd been looking maybe for somebody, what kind of interactions they'd had, was there a common thread. None of this will prove that there's been a rape, but it could be really powerful evidence when it's presented in court of the way the perpetrators behaved. And I think without the specialist rape training, there wouldn't have been necessarily the consistency of approach that we're seeing now.
Carolyn?
Yeah, on that point, I understand that currently if somebody presents at NHS hospital a suspected victim of spiking, potentially who could have been raped. There's no statutory obligation for the hospital to take forensic tests, which could help a rape prosecution later down the line. Is that your understanding as well? And if so, why?
Yes, that has been raised with me, actually. So that's a good point. What I've heard from the police on that issue is that the biggest barrier to getting a conviction for a spiking followed by a secondary sexual assault, but in establishing the spiking, is the length of time on toxicology anyway. And they say that even a victim who goes to the police force the following morning and has a standard toxicology test, will often, the substance will often have left their body. That's why actually the most important, or one of the most important elements of the spiking announcement at Christmas wasn't just about the change in the law, although I've said I think that's very important for accurate recording, but it's also about the investment that's going into research, into on-site testing. Because, and also actually the work that's happening with the SIA, the security industry staff, on identifying when somebody isn't just very wasted, which might have been an expression used in the past, but actually looks like they might have been a bit victim of spiking because of the way that they're displaying, that actually you might hopefully in due course have a system where it would be normal for a bar to have those on-site spiking tests, that they could just go around the tables and say this has got a substance that is not what we would sell in the bar, and immediately then you've got an evidential connection that would allow the police to look at other factors that would lead. So I think it is a point that's been raised with me before, I have to say, and I'm happy to take that one back actually, but when we're talking about toxicology, we're much more focused on rapid, like on the night testing, probably of the drink, not the person. And I know it's not all drinks, but that is still, I think, quite a large component. And I also think we need to see some of these cases getting convictions just to start the ball rolling on that, and that's been something that's been, you know, that has been a barrier, but the police basically say that the toxicology comes too late, and that is a big issue with spiking.
Thank you. The MOJ's risk of serious recidivism tool for sexual offending has been found to underpredict contact sexual reoffending. What are you doing to address that?
I didn't know that, actually, Chair, I have to say, but I'm very happy to take that back and look at it. But I think one of the things that I probably would refer to, and I won't go through it all, I do think there is this point about certain individuals being high-risk people. And as I say, I'm very interested in the police using their safeguarding tools, irrespective of criminal justice outcomes, because I think there is a huge preventative barrier that could be used more widely. And I'm very interested to know why we still see patchy performance. If you look at, for example, when those orders are made, some forces use them more than others, which suggests there's a lack of consistency.
Do you give us any examples of forces that were using them effectively?
I'm not going to name any, okay, but I am aware of forces who use them less.
Okay. I was asking you to sort of applaud the good as opposed to shame the bad. Kim.
Thanks, Chair. Good afternoon, panel. Minister, the Domestic Abuse Commissioner has informed our committee that there is a culture of disbelief towards victims of domestic abuse by the police. So I wanted to know why you believe that there was still this issue by the police, and what are you actually doing to change that?
Yeah, it's a really important question, because we know that 1 in 5 of all offences that comes to the police is a domestic abuse offence. I mean, it's a major part of what the police encounter. We have had a system that was actually, I think it found its roots in the Domestic Abuse Act, of specified domestic abuse training that has been administered, I think, to all forces. By the end of this year, it will be all forces apart from 3. And I have just been reassured, by the way, one of the forces that won't have had it, I think, officials can jump in if I'm incorrect, and if I am incorrect, I'll write to you, but one of them that won't have had it is Avon and Somerset, because they're seen as having such advanced practices in relation to violence against women anyway. But it's called the Domestic Abuse Matters Training, and the feedback we've had, including from the sector, has been that this is really, really effective. I think the other thing about domestic abuse and sort of developing our understanding has been really understanding coercive control. And it is a relatively new offence. I mean, it was only created as an offence in 2015, And then it was only, since we've been MPs, which isn't very long, it was only recognised that it could outlive a relationship in the Domestic Abuse Act 2021, knowing that it can stay as a tool of abuse, even if it's an ex-partner that you're talking about. So some of the law is still at quite an early stage, but I think that is why the domestic abuse matters training has been important. We are hearing really positive things. I actually read one of the transcripts, I think it was a Women's Aid or even the Susie Lampley Trust who gave evidence to you, and I saw that they talked about domestic abuse matters and they responded to it positively, and that's consistent with what we've heard. So specialist training. The other thing I think that is a really important tool in domestic abuse, which is something which has taken quite a long time to come on stream and is only starting as a pilot, I think, next month or the month after, but are domestic abuse protection orders. And that is going to be a composite order where a domestic abuse victim can either go to the magistrate's court or the family court, basically, whichever's quicker, and they could get a range of things. They could get a non-molestation order, an occupancy order if they want to stay in the house, a stalking prevention order, all in one order, all through one court hearing without having to go back and forth again and again and again. And I think that will be a very powerful tool once we've got that operational. We're piloting it through a number of police forces, so they're going to get used to making those applications. But I think, with domestic abuse, you're always talking, yes, about a criminal offence, but also about family law. And the vast majority of domestic abuse victims who end up resolving their problems will probably do so through the family court. I mean, that is where the majority of it is dealt with. And so a DAPO, as we call them, if that was something that came on track with, we're expanding eligibility for legal aid, we think that will be a really powerful tool in better protecting people in a much more focused and immediate way from domestic abuse.
We know that some type of those orders already exist to a certain extent now, don't they? And I think the issue that we're aware of is the implementation and the enforcement, and I think that's one of the major issues, isn't it? And perpetrators feeling that they're not worth the paper they're written on to a certain extent, and they'll carry on with their behaviours. So do you have confidence that this new version of order will be stronger and be enforced in a different way?
That's a really good point. Yes, I'm very hopeful that it will, because I think that I was talking earlier about police recording of course of conduct type stuff. I think this has similar elements in that it brings all the behaviours together and gives them kind of a multiple resolution in one focused order. I do think that we're also getting much better when you have, for example, perpetrators who are out on licence or something like that, where they're using GPS tagging. I think it is night and day the ability to monitor offenders from where it was, say, 10 years ago, when they had the old radio tags around their ankle where all the probation could tell was whether they'd left their home or not. With a GPS tag, you can monitor, to the nth degree. I'm not just saying this for effect, but the Lord Chancellor was tagged. I don't know if you saw this, but he was tagged the other day for 24 hours, and he went home on his bike to challenge the tag to see if it could follow his route. They knew every single within a millimetre of where he'd been. So offender management has got better, and things like, frankly, using better technology is a big important tool in that. Because the DAPO is only at a pilot stage, it is hard for me to say for certain how effective it will be, but the intention is that this is going to be the most robust and comprehensive and effective way of protecting victims, irrespective of whether they seek that order in the magistrate's court or in the family court.
Thanks, Minister. Home Office Commission report that was published last year said that 1 in 4 women victims of abuse suffered significantly in terms of their mental health as a result of what the police either did or didn't do. So, and again, what are you doing to improve the processes for women so that they do have a positive experience?
That's a very good question. So I think I probably would take it back to some of my earlier answers. I think a trained police force really matters. And actually, when we hear from victims who have had a positive experience of the police, it is something that they really hugely value. And we do know that specialist training is a very important ingredient of that. But the second element is the support. And we call them in a shorthand, it's actually the MOJ who provides these, ISVAs and ISDAs, Independent Sexual Violence Advisors, who would deal with a RASO case, rape and serious sexual assault, or IDVAs, Independent Domestic Violence Advisors. When we came in, I think there were a handful working in the system. We're now on track to have 1,000 of them. And the ambition is to go further from that. And we want anybody who's going to see the police with dealing with a serious crime of this to have that kind of support, because we know it is basically like having a friend who is not, as I say, not official. They're not your lawyer, they're not going to give you legal advice, but they are there to talk you through the process. They can make representations on your behalf, and we know that that can be really fundamental to the way a person feels about the process. And actually, with one force that I went to see, when I was talking to them about their performance, there were ISVAs in the room also giving feedback that they'd had from their clients, and they weren't political or in any way official or in any way they were all kind of, they're linked through Safe Lives. And it was really powerful. They were anonymised, the accounts they were hearing, but it was really powerful hearing what victims had said to them about how they felt about the criminal justice process, how respected they felt they'd been. I have to be honest, in some cases they said, we only saw it through and got the conviction because of you, because you were there for us all the time. That's not to replace the police, it's to complement the work of the police, who, you know, will be going through numerous cases and have a slightly different slightly different set of priorities. But we know that when it comes to victim support, having that tailored kind of person with you is critical. But I also want to just say, I do accept your question, which is a bad experience of the police can have a very serious negative effect, and I want to concede that and say I have considered that carefully and I recognise that evidence.
Thanks, Minister. Kind of following on from that then, in terms of do you believe then that there's been a reduction in the confidence of the police because of the violence against women and girls that are being perpetrated by police officers, and the fact that women might feel not confident that their case will be dealt with positively as a result of some of that?
I don't think you could sensibly suggest that those major cases that have taken place or come to light in the last few years have not had an effect on public confidence. I mean, they are shocking to every single person in society. And I think it must be very, very difficult also for the diligent and conscientious police officers who do this work to a high standard, because it profoundly undermines their work and their efforts. And if I can talk just briefly about the Angelini report, because I do think that's the one that's the most topical. I do think that the Home Office, working in conjunction with the College of Policing, has got in place, and this started from really when the crime was committed, a much, much more robust process for vetting and disciplinary. I still think, particularly the Met, because it has been the focus, there is a big challenge for Mark Rowley in restoring confidence in that particular force. And one of the things that I have been really sort of following closely among his commitments is what he's been saying about basically getting rid of officers and really rigorous screening to their histories of any previous sexual allegation or domestic violence allegation. And I think that he would recognise that he has, that there is a high standard to be met. And I do think that the public will kind of, are entitled to see results from that, because, this is a big moment, particularly for the Met Police, and I think they've got a major challenge. And I think that it can be frustrating as policymakers and politicians when there's such kind of deep thought going into this, a really important fabric of laws, which in many ways are really, world leading on things like, we're one of the first countries to criminalise coercive control and understand it properly. We're one of the first things like non-fatal strangulation in the Domestic Abuse Act, the rough sex defence stuff. I mean, there's lots of countries who are still grappling with how far they should go in terms of statutes on this. But what you need to know is that you can do all this work in Parliament or in government, but that it's going to be enforced at the end of the road. And I am very encouraged by police methods. I've talked about rape. I'm very encouraged by the huge amount of work that's gone in to improve the kind of the vetting and the checking. But I do think that there has been something that's been profoundly damaged in the last few years, and that's going to take time and really demonstrable work to address.
I was just going to say, though, given that the police is probably generally large male-based organisation, and there is a culture of misogyny, and I'm just curious in terms of how that is challenged in terms of changing heart and minds in these big organisations to deal with some of those major issues.
It's a really good question, and I'm sort of going to return to an earlier answer, but I'll put it in perhaps a kind of simpler way. So I think the police needs a more diverse workforce, and that is a better gender balance. One of the things, actually, and you may have noticed this, when Dame Louise Casey wrote her review into the Met, she commented on some of the security that applies on the Parliamentary estate and beyond, and that there's sort of sometimes certain aspects of being a police officer, for example, if you hold a gun, is nearly always something that's very attractive to male officers, a sort of man job. I think that necessitated an immediate response, actually, and I think we've even seen a bit more diversity in the policing in that kind of role, but there are numerous other examples, and I think that is something that should be a real focus, that there shouldn't be man jobs in the police, that there should be a more diverse workforce. It's not just a good in itself. I think it ends up having it contributes to a healthy dynamic. But I also think leadership matters, and I do think that chief constables do play a really vital role in that. And I have looked at sort of the police disciplinary procedures that existed before. They're quite complicated. There's an independent lawyer who sits on the disciplinary, and there's lay members, and there were, if there was an issue with a police officer, that was basically dealt with out of the hands of the chief constable, when they were the person who was closest to the performance of that person and knew much more about what they were doing day to day. And historically, the reason we're acting through the Criminal Justice Bill was because they would sometimes get an officer exonerated by a panel of people who they may have had almost no contact with, when they continued to harbour very serious misgivings about the conduct and attitude of that officer. And I think that was not I think that was a disconnect that was quite worrying. And I'm really glad that we're moving to a system where chief constables basically have more power on this, because they are the ones that we have to entrust to know their force and to know the culture that they're trying, and ultimately they're the people who are accountable, and I think that's really important. You can only really get cultural change if you empower the leadership to drive it through.
I'll just take you back to the Angiolini report, which had a very worrying, and apologies, I don't have it in front of me, so I'm going to misquote it, but a very concerning comment about a culture of misogyny that allowed attitudes to thrive, where misogyny went unchallenged, where almost arguably officers were encouraged to exhibit misogynist views. Are you confident that culture's being addressed?
One of the things I think that does worry me, and over which I don't have any sort of direct involvement, although I have had other ministerial conversations, actually we've had them at every level in the Home Office, is about the WhatsApp kind of culture and the formation of small groups of people, and the way that there's a sort of back chat channel where certain groups of like-minded people can kind of, and that is not something that is just confined to one force. That's something where that kind of conduct that I think, frankly, could be described as gross misconduct has appeared in other forces too. And I think that is something that I continue to have concerns about, the WhatsApp culture.
Thank you, Kirsten.
Thank you. I'm just going to come back to the point that I was trying to explore earlier. So you've spoken about a WhatsApp culture, a back channel, back chat. You've spoken about a culture of misogyny. And again, on this point of automated systems and AI, what do you think the protections are which are in place or not, as the case may be, to stop this culture, this problematic culture, from being hardwired into these automated systems and AI, and therefore making sure that the biases and the problems that we're trying to get rid of are not cemented in, rather than the opposite.
Sorry, I hope I've understood your question correctly. Are you suggesting that too much reliance on AI could embed sort of...
I'm not.
Sorry,
I'm
understand.
asking a straightforward question. I have no angle here.
Yeah.
It's very clearly the case that in any automated system or system of AI which is going to be looking at people's behaviour and making judgments on that, it's only as good as the information that goes in. So if the information that goes in comes from a culture of misogyny, where there are back channels, back chat, WhatsApp chats that are problematic, then the AI or the automated systems, by virtue of how they have been set up, will have that bias inbuilt into them. How is that to be prevented from happening?
Well,
which is a question that we should always ask when we're thinking about AI and automated systems, which have much merit, but not if they're not
it's a fair
started
question.
properly.
It's a fair question. So I think I was possibly approaching it more simplistically in relation to your first question, which is that we know that data isn't always accurately recorded, which can lead to I gave the example of sometimes basic things like the relationship between perpetrator and offender, and that, I suppose, in a way is less subjective. But I suppose what you're suggesting is, well, if you had somebody who didn't take domestic violence seriously, how can we trust them to enter the right?
Not really. No.
Right. Enter because
the parameters that these systems are set up. The parameters that are set up with the system or within the systems can only ever be as good as the human beings which set them up. They can only ever reflect what the human input is. Yeah. If the human input reflects that misogynistic culture where there are these problems that we've all identified, then that would be a challenge that would need to be dealt with and dealt with swiftly. Otherwise, you are building in the bias and cementing the misogyny rather than tackling it.
Well, I think it's a hypothetical. I think that's a very fair point. And I think, look, going back to what I think the real point you're driving at, which is how do we kind of root out misogyny in the police force? I've talked about cultures, I've talked about leadership, and I think that really matters. I've talked about better vetting, and I've talked about more diversity. And I think sometimes when you're talking about this, it can feel a bit abstract, as if, okay, but you've still got this very male environment and it's really problematic. But actually, if you look at a lot of workplaces, well, politics isn't a bad example. If you look at that 50 years ago, it would have been much, much, much more masculine and had a different sort of prevalent mindset. And actually, improving diversity has improved the quality of select committees. I'm joking, but actually, there can, changes in leadership, changes in diversity across a workplace, new ways of working can embed change quite rapidly, actually, when it takes hold. There's no doubt that these issues have been thrown up and they are acute at the moment, and particularly the sense that people will, with the WhatsApp groups, to be specific, that they'll ridicule or that they'll that they'll profoundly undermine victims by making fun of them or making abusive remarks about them, and that this will go either undetected, or if it is detected, it won't be dealt with stringently enough in a disciplinary process. These are really, really big questions. And actually, I think it is a really important part of what the College of Policing is trying to do in the way it's setting out standards, and the MPCC is dealing with this, frankly, emergent problem that wasn't one it really had to deal with before, but now is something that is absolutely critical in how it deals with it, how it treats it as misconduct, how the consistency with which officers are treated who engage in this kind of conduct. And the IOPC, sorry, I should add, I think the IOPC has a role in that too, because they're reviewing a number of forces at the moment, I have to say my own, for conduct of this nature, which has been drawn to their attention. So there is going to be a wider police conduct question, which I think is going to be engaged with by the IOPC on this.
I think I'll leave it there, but may come back on another occasion.
Thank you. Can I talk about intervention programmes and His Majesty's Prison and Probation Services and what actually works? What sort of data are you collecting on programmes like building better relationships?
So my view is that the evidence on perpetrator programmes is quite thin at the moment. I don't know how much we can really say that perpetrator programmes make a difference. this is a view I've expressed actually as a minister. I'm not. I think we urgently need some data on that. What I think is far more important than treating perpetrators or people with convictions is what we're doing at the very start of people's lives. And there are 2 or 3 changes that I'm hoping to make that I think are really important. First of all, I think the most important piece of work that's going on in misogyny in Parliament is the pornography review. Because although I think the Online Safety Act is going to make the online world a huge amount safer for children, I still think that the fact you can access violent pornography on a phone and anyone can do it, and some people do it in public places with women sitting next to them, I still think that has an unbelievably harmful effect on young men's attitudes towards women. And therefore, I think that review, when it comes out in the summer, is a really, really important, I think, moment actually for society. And I, really hope that we see really strong policy proposals coming through as a result of that. So that's one thing. The other thing is education. I know that sounds a bit weak, the word is used in a really loose way, like we need to improve education. But I still think there's a very important role for children, actually maybe even in primary school. I think we've even discussed this previously, where things like intimate image abuse are actually really, in the mind of a young child, you can explain that as an intense form of bullying, and children are very well versed on sort of anti-bullying stuff now. It is an intense form of bullying. Intimate image abuse of a teenage girl could destroy her life, and it will seem funny and like it's something that young boys make fun of, but it has catastrophic consequences. And I don't think we do enough at that very early stage, maybe even at the end of primary school, going into the beginning of secondary school. I think that's another focus. And then I think another really important preventative sort of measure, I suppose, and I think this goes a little bit into building men in a bit more, is I think that young men aren't really part of the conversation, and I think this is one of the reasons why there can be this risk of them militating towards some of the more aggressive male influencers, because I'm not sure we've quite yet figured out how we bring young men into this in a way that doesn't immediately say you're a risk, you're a threat. And so I'd like to see a sort of a bigger role for boys in this conversation. And then the third thing that I would say that I think is really important is on domestic abuse. Actually, we've done good work in this Parliament in bringing and identifying children as victims of domestic abuse. But it's also the case that if you grow up in a household where there's frequent domestic abuse, that can entrench attitudes and behaviours that could become very, very harmful. I mean, I'll give you one example of a case where there was a background of serious domestic abuse in his childhood. Now, it doesn't change the seriousness of his offence, which was absolutely disgusting, and he's rightly serving, a whole, or I think more than 30 years. But Jordan McSweeney, who was a very, very, very serious killer, hugely misogynistic, it's one of the most shocking offences. Actually, when you looked into his past, there was a serious background of domestic abuse through his childhood. And so better link up between statutory agencies, because let's be honest, those children could be at risk. If that's what their day-to-day involves, then you're creating children who are particularly vulnerable to that. So those are my thoughts on prevention, which I think start very young.
What input have you had into the RSAG review?
I know, I think this predated me becoming a minister, but you know that we've discussed this. It's something I've discussed within the Home Office and in an informal way, and I just want to make one point on this. I don't think a teacher talking to children about attitudes is enough, and I think it's too much to ask of a teacher to shape the attitudes of a classroom, particularly given how strong their peer group influence will be as they go through school. I think it's too much to ask of them. And I also think that some schools are already delivering quite ambitious RHSE, where they really get into sexual harassment and things like that quite young. But I do think this is where it needs to, I think there needs to be a bit more consistency in education, and I'd be starting it really young. And I think, as I gave an example, I think intimate image abuse, which is frequent and is really common with kids with phones and all the rest of it, is something that you can start that conversation through the prism of bullying and what that feels like. And children do understand that. Even when they're very young, they understand bullying. And that's, I think, how you start the conversation.
We shouldn't shy away from teaching age-appropriate RSAG in
No, I
primary
really
schools.
think we shouldn't. I think it's one of the tools, and as I say, I don't want to land it all on a teacher's desk, because I do recognise there is an inherent limitation to what happens in class. But I think it needs to be out in the daylight, because once you get to the stage where the perpetrator is
serious or an adult or has become a persistent offender or is on that pathway through a sequence of low-level offences, you've already got somebody who's got really problematic behaviour, and I think there's a lot you can do to kind of catch them at an earlier stage in their life and hopefully change that course a bit. And as I say, I mean, I just think, you know, and I've said this on the floor of the House for the backbenches, I just think a world where young children can use a phone to click and access sort of violent pornography is just... One day I think we'll look back on that and be absolutely appalled. And I know that the Online Safety Act is absolutely critical and transformative in stopping that. And I'm really, really pleased with everything we've done on it. But I actually worry about porn more widely than that. You know, it's still there. And so much of it is really misogynistic and violent. And it really normal. And if you look at the most serious offenders, like the really shocking cases that have caught the public's imagination, what is the common thread with all of those perpetrators in addiction to violent porn?
Yeah.
I think.
So look, I'm going to give you some quick fire questions, and I suspect we're going to get really thin answers in response.
Can I just bring officials in as well? I sort of feel like I'm...
No, we're here to hear from the Minister.
Oh, okay, that's
so
fine.
look, you said that the evidence is thin on whether building better relationships works. We have heard that there are significant waiting lists for that programme. Do we know what those waiting lists look like?
I don't. I would just say this. What I've heard from because I've been very interested in whether or not perpetrator programmes work, I've heard that some work better than others, and I don't think the data is strong enough on this. And I have to say, I'm going to be honest with the committee, I have heard some scepticism from practitioners as whether perpetrator programmes really work, because you're dealing with people who are quite far down the line with this behaviour. So, for example, in prisons.
So we don't have enough evidence as to whether it works. We don't know what the waiting lists are. And we don't know what the reoffending rate for people on probation who are waiting for a place on a perpetrator programme is. What are you doing to make sure that government's collecting that data?
I've requested, through the Home Office, a comprehensive data review of the perpetrator programmes it's been funding.
Fine. I think we will probably take that. We
yes,
know that it's
and I'm very happy to return to you because I've made that request.
Thank you. And so we don't know whether the availability of those programmes is even meeting the demand for the programmes.
Well, I think one of the things to remember is that sometimes a perpetrator programme is, for example, something that you have to do in prison. So even if there's demand for it, it doesn't necessarily mean that the person is going in with a, heart and mind desperate to go into a perpetrator programme. It's just a sort of tick box that they have to do as part of the rehabilitation system in prison. In fact, that's one of the questions I've asked about how many people are really actively engaging in this stuff because they believe they have a characteristic they'd like to change, or how many are just
going through the motions.
Going through the motions, yeah. I'm much more interested, just to tell you now, in the safeguarding powers that the police have, because I think these are highly effective if they're used right, and also the management of offenders afterwards in turn. I've talked about MAPA and the Sex Offenders Register, which I think the evidence shows is effective at preventing the most serious crimes. That's where the evidence sits, that it does seem to be very effective. And we're also doing other things which you'll know about, like preventing people from or closing the conditions in which a perpetrator can change their name, and just closing off some of those loopholes that might have allowed somebody to slip through the system. And we've been looking very carefully at that.
Thank you. Carolyn.
Thank you, Chair. Given everything you've just said, Respect, the organisation Respect, they told us that the government does not value the infrastructure that the third sector contributes to the perpetrator intervention space. Is that a fair assessment?
Well, the government is giving a huge amount of money to perpetrator programmes at the moment. I mean, the Home Office funds it by about £19 million a year. And I've met Jo Todd, and I know, actually, I thought she was really impressive, and I really enjoyed her work, and I know that hearing about her work, and I know that she occupies an important role overall. I definitely don't think there's a lack of engagement, but what I have been a bit concerned, and I've only been in for a few months, I do think there's a lack of evidence. And I do think it's really important that we look at who's been into a perpetrator programme and who's reoffending. We don't hold that data. And I think it's hard for me to say, we are unequivocally committed to perpetrator programmes when we're not actually sure how well they work. And that's just a true fact, and that's why I've requested that data.
So would you say it was fair that there's nothing that you can learn from programmes that they put on because they're not providing enough data to actually inform your decision making?
I think that was an answer that she gave to you, though, because I did look at the transcript of what she said, and you asked her, somebody asked her about data, and she, I think, conceded that there wasn't very much. She talked about whether people felt safe, and I think we do need to go a bit further than that, actually. I think we do need to look, I'm afraid, at the black letter reoffending rate. But
do you feel that you could learn something from the role that they play? Are they doing anything that you can learn from?
Actually, I think that's a very fair point. And one of the things that when I spoke to her, that when we met, which was before I was a minister, she did talk about a greater role for boys and men, and I've just made that point myself. So yes, of course, and we absolutely value her expertise, their expertise. That's not a closing down. It's simply saying, there is an urgent need now for an evidence base for that for this work.
So the Victims Commissioner for England and Wales told us that victims are not given information about interventions that their perpetrators may have received or participated in. Is that a concern that you recognise, and should the victims be kept up to date as to what their perpetrators are having to go through as part of their sentence, their punishment, or whatever you want to call it?
I actually didn't know that. And I will take that away. Let me just make one point about the DAPO pilot, which I was talking about before, which is beginning in May. One of the things that is very much envisaged under that pilot, and you'll recall that was a multiple kind of domestic abuse remedy where you could get many orders in one scheme. It is anticipated that participation on a perpetrator programme could be a condition of that pilot. So not only are there like a non-molestation order or other restrictions on your movement, there could be positive obligations, which is one of the reasons it's such an unusual legal remedy, because normally you just stop people from doing things. You don't positively require them to. And victims will know about that. So I hope you'll see, I'm very happy to catch up with the Victims Commissioner on that point, but I think you will see a developing pathway on victims knowing more about what's been required, because it would be part of the DAPO. And as you can probably tell from my answers, we are kind of putting quite a lot of hope into this, because we think it is a route to swifter, more comprehensive and more effective justice for domestic abuse victims.
Okay, so given that you've already said there's not enough data coming out of the intervention programmes,
well, there may be. I've requested it, but I think it's now.
Okay,
it isn't something that has been presented so far. So I think we do need to see that data.
Did that play a role in you deciding to come forward with your own set of standards rather than adopting Respects?
Well, I think you know, Carolyn, I've been very interested in this area of the law since I was elected, and I've done the stuff on pornography. I mean, I've worked closely with the Children's Commissioner on issues like this, and she, I have to say, has, I've been to presentations she's given in Parliament, in the Lords, in the Commons, where she has said that, she has told an audience absolutely staggering stories of child-on-child perpetrated sexual abuse, where the children have accepted that the reason they did what they did is because they saw it in porn.
Normalised.
And actually, another consideration I should have drawn to your attention when I was giving that answer is we have a sort of child sexual exploitation unit in the Home Office. We meet once a month, and there's an amazing team of officers who tell me what they're up to and how they're, developing their response. Really, really impressive work. And one of the things they say is that the fastest growing cohort of perpetrators of child sexual abuse are other children. And I think that pornography and again, they agree that pornography has a link to that. So I didn't just make it up. The evidence is really worrying around that.
But Respect set of standards have been used for 15 years. So do you believe that the set that you've introduced are going to be better and will outlive Respect set of 15 years, widely used across the sector?
I think I've already said I'm very respectful to Jo Todd and the work that she's doing, but the reality is that we do have a problem with this area of the law, and I do think there's room for imaginative policy making, and I don't think it's unreasonable to draw on other influences.
Okay, but it's not just Respect. You are a bit cynical about the set of standards, and some of the things that they've been accused of being not victim focused, particularly in terms of raising awareness of the impact of abuse on women and children survivors. So what kind of reviewing process will you have over the standards, and how will you make sure that organisations are adhering to them?
I think, look, I I think I have to fairly reflect the fact that victims, the third sector sort of victims organisations sometimes take a different view of perpetrator programmes to the providers of perpetrator programmes. They're not all aligned actually on that. I have to just reflect that. I've heard that as a minister, so and it is also, I think, true to say that I will be, looking very carefully at the reoffending rate that comes from perpetrator programmes. But I would also, I think, say this, I suppose there are a certain limitation in the tools that you have as a minister, and in relation to victims, I do think my focus is on sort of their protection and the things that improve either their prospect of getting justice or the safeguarding tools that are available to them. And I suppose if I'm given a choice between sort of victim and perpetrator focus, my focus is more heavily towards victims. I will make that concession now.
Thank you, Chair.
Kim. Is it me? Sorry.
Yeah.
Great review.
Oh no, don't worry.
I thought I was doing F, but there you go.
Yeah, we're on F.
Oh, what I thought we were on E. Sorry.
We're fine.
Sorry, Minister. The average wait time for rape cases to go to court now is 18 months. And a fifth of those cases in the last quarter were halted on the day. And I just wanted to know, from your point of view, what impact that has on the mental health of victims and what are you doing about it?
It's an excellent question, and I will answer it as fully as I can. So, even though I am really, really pleased by the progress that is being made in rape prosecutions and convictions, it is the case that there are delays in the Crown Court. And the reason for that is because during COVID, a decision was taken to continue with full juries of 12 people, because it was considered that the absolute sort of touchstone of the right to a fair trial was to have your liberty decided by a jury. Not every country did that. But that was a decision we made, and when I look back and reflect on that, I still think it was the right decision, and I still think the best route to getting justice, which has to be our priority, is through jury trials. But there is a backlog, particularly in the Crown Court, although it's coming down. So 18 months is the average time from when the CPS reach a charging decision to having the case disposed of is 1 year, 54 days. That's the average waiting time. It is actually, I think you were saying 18 months from start to finish. Even before COVID, or even going back a decade, it would never have been immediate that you get a rape trial. There was always 9 to 12 months. So we are talking a matter of months, not years. We are doing everything we can to accelerate justice for rape, and I'll just set out a few things we're doing, all of which I think are important. We're recruiting more Crown Court judges. We're on track by the 2024-25 year to have 1,000 more Crown Court judges working in the system. We've also kept the 20 Nightingale courts open. You'll recall they were the emergency courts set up to deal with the unusual circumstances of COVID. And we also have accepted all the recommendations of the Criminal Legal Aid Review. We've increased pay for practitioners, for defence and prosecuting lawyers by 15%, because we completely value the integral role that the lawyers and professionals play in the service, and we hope that that's going to contribute to getting cases down. I think another really important thing to just draw your attention to is that we do have some older cases in the system, and the senior presiding judge, wrote to the Lord Chancellor about 2 weeks ago and made a commitment that there's 181 cases in England and Wales that are more than 2 years old, and he made a commitment that every single one of those cases will have been reviewed by July. And there can be, by the way, some complex reasons why a case takes a long time. I'll give you two. Even in his letter, he said some of them are collapsed trials. In other words, the jury didn't reach a verdict. They were split. So that needs a retrial. So some of those old cases have had that. And the other cases which are particularly slow in the system are historic child sexual abuse cases. So if somebody comes forward, and we want them to come forward, and we absolutely want them to come forward at any stage in their life. There's no limitation period that applies to the offence of rape. But if you come forward in your 40s
and you're going to talk about something and make an allegation about something that happened to you when you were, say, 10, the investigations for those cases are slower and they are more difficult, and those cases can take longer. And then another category of rape case which can be slow are the grooming gang cases. And to give you one example, an illustration of why that case, or why an example case might take time. There's one case that the Greater Manchester Police have got going on at the moment where they're putting together a group of defendants in that grooming case who don't all know each other. And they had to make a difficult decision about the categorisation of who was appropriate to be defendants to the same case, even though not all of those defendants have even met each other, but it is one trial and one rape trial. Do you understand the complexity? So some rape cases are highly irregular, and that can contribute to why they've taken longer.
There's been some suggestion also that we're seeing an increase in the number of defendants in RASO cases pleading not guilty as a result of the backlogs and pressure on the prison estate. What do you think is the impact, again, on the victims?
One of the truths about rape prosecutions is that defendants nearly always plead not guilty, and they nearly always have done. And the reason for that is the social stigma of being a rapist is so high that there's no incentive. So even though there are discounts available for early guilty pleas, you might get that in a domestic burglary, for example, it's not the same kind of offence as rape. So we've looked really carefully at this, discussed it within the MOJ, but ultimately we almost never see anybody pleading guilty to rape, early guilty pleas, or not almost never, but it's rare, it's always been rare, it's never really changed, and that's because of the social stigma to being a rapist.
Thanks, Minister. 64% of prosecuting counsel have said they will not be reapplying to be on the RASO list, and 34% of defence RASO counsel have said they no longer want to conduct these cases. Could you explain what happens to RASO cases then if there's no counsel available?
Well, we've been having discussions in the MOJ with senior practitioners at the Bar and the Criminal Bar Association to see what we can do, and we concede immediately that this requires our urgent attention. I mean, just one point I would make, which links to something else I've said. RASO cases are overwhelmingly conducted by female practitioners, and that is because when people are looking for defence, they say they want a woman. And so one of the things that I have raised, and I also said this when I was on the Justice Select Committee, because it was something I've always been, more than any other crime, only really women lawyers are made to do this work. And I do think we need a bit more diversity. We would have a bigger pool if actually we had both sexes doing that work, but you will find that the overwhelming majority of RASO practitioners are female, and that's because the defence think if they're defended by a female barrister, they're more likely to be found not guilty.
Also, the CBA have said the funding is a core reason for the number of barristers doing RASO work. If the government is serious about tackling rape, why is it not adequately funding the barristers needed to do the work?
So one of the things that, I'm going to bring Amy in on this actually, we did talk about funding, and actually the rates were, I mean, they were higher than when I was in practice. They've gone up. I'm not saying it's the most lucrative work, but I'm not sure that funding is the issue. I think there is a bit of an issue actually with the intensity of going from rape case to rape case to rape case to rape case. And if you look into the detail of that review, the biggest reason why people were saying they didn't want to continue doing it was well-being, not money. And I have to say, that's one of the issues I have. And I'm not making a political point, but I know that Labour have suggested they're going to introduce rape courts. I think you'd really struggle to find judges who want to sit in court and do rape, because this is really tough, gruelling, emotionally draining work. And actually, a lot of people, whether they're practitioners or judges, would prefer a more diverse practice because of the emotional challenge that comes from doing RASO cases. And I think we need to be more honest about discussing the wellbeing element and what it feels like to be spending your professional life dealing with some unbelievably difficult and gruelling cases.
Thanks, Minister. Just a couple of questions on the use of Section 28 in RASO cases. Yes. So earlier this year, the Lady Chief Justice called for the use of Section 28 in rape and serious sexual assault cases to be paused due to concerns its use may reduce the likelihood of conviction. Do you share the Baroness's concerns?
Right, this is a really interesting question, and I have to say I was an early advocate for Section 28, and that came out of my time on the Home Affairs Select Committee. We did an inquiry into rape, The Shadow Home Secretary was the chair of the committee at the time, and we heard evidence from the legal professionals who'd undertaken rape reviews in Wales, Scotland and Northern Ireland. And they didn't agree on everything on the prosecution of rape, but one of the things they strongly agreed on was the use of Section 28 as a way of giving victims the chance to give their evidence ahead of trial without having to confront the perpetrator behind closed doors, privately, and to get their involvement out kind of over and done with earlier so that the trial could then kind of move on without them. And that obviously wasn't why it was done, but I think that was in our final report. It will be a matter of public record, and the MOJ took it up, and it has been rolled out. When I speak to victim support groups, it is true to say that Section 28 is getting. It's not for everyone, but those who do it have. The victims who've done it have given positive feedback. I'm aware of a some preliminary data from Cheryl Thomas, which has suggested that it doesn't lead to as high a conviction rate. And I'm also listening carefully actually to practitioners, legal practitioners, who say, well, it sort of interrupts trials and it makes it difficult to get a listing date for the hearing because we have to do a day of Section 28. And we're listening to all of that. The only thing I would say is that Professor Thomas, and we do respect her a huge amount at the MOJ, but that was interim findings. The MOJ is doing its own piece of work. I'm going to bring Amy in, actually, but just quickly to simply say, I do think it's quite powerful to be able to say to a victim, you don't have to face him. You can give your evidence and be cross-examined in a private room. Your case may not come on for another 6 months, but you don't have to do anything. You're over, you're protected. And it doesn't surprise me that victims say that that can be a supportive environment, and I think that's a very important starting point. But Amy will talk about the review that we're doing into the data, because the data does matter. Of course it matters. Amy?
Yeah, I don't have a huge amount to add, Minister. As the Minister has said, we're doing a comprehensive analytical review. We did a process evaluation last year, which we very much accept was limited because we were always going to be doing this much bigger full analytical review. That will be published by the end of the year. I think what a lot of senior people who have spoken on this issue have said at various committees and in the public have said is, until we know, we should be pausing any further rollout or any further changes. And I think that's also our position. We're not looking to make changes now until we know what the analytical review says. And then we'll go from there once we have that.
Did you have any information at the moment in terms of whether it is or isn't having an impact on convictions or not?
We have within the MOJ. We have no evidence on that at the moment. I mean, the analysts are working through it, but there is nothing to share at the moment. As the Minister said, there's Professor Thomas's kind of interim findings that she wanted to give a flavour to the JSC as part of their inquiry. Yeah. It's one of the big problems here that, until that analytical work is completed, which I think will be hugely useful, we're working with the anecdote, which, as the Minister says, is really positive from victims groups, more mixed from other groups.
I think I'm right in saying that a judge has a discretion to order Section 28. So it isn't the case that every rape victim is sort of funneled down the compulsory pre-evidence, but some victims choose it. And historically, it's been a procedure that's been reserved for vulnerable witnesses, and it's I think it's always used for children. And that works very well because children don't respond well to the big court environment, and they can talk through the way they're cross-examined is different. Everything's different about the way you get evidence from them. So already it's something where the victim doesn't have to choose. But I think, look, I know where you're going with your questions, which is, does it reduce the risk of getting a successful conviction? That is where we're going to be focusing, of course, our attention.
The other thing, if I may just add, particularly when ministers predating Minister Farris were making decisions about rollout, I think in many ways they were very focused on a cohort that would never have proceeded with a trial if it weren't for the existence of Section 28. And so in a way, that's kind of the group we can't control for, because hopefully we will be getting many more people through the system who otherwise would have gone, I can't bear the thought of a live trial, and therefore I will withdraw.
Okay, so it was rolled out as a pilot project. It's been extended. But there has been some criticism around the technology. So just curious in terms of why you decided to go ahead in terms of wide-scale rollout when there have been some issues and concerns and the impact it's having on vulnerable victims.
As I say, I think previous ministers were incredibly taken by the arguments made by victims groups about the importance of having this in place. And I think Minister Argo gave evidence at the Justice Select Committee last year about kind of the decisions that were taken then and how important ministers felt it was to have it available. The technology is there in every courtroom. We know that there are issues in some courtrooms. It's something we're continuing to look at in various different ways in terms of technology upgrades, something HMCTS are working on. We understand there are issues, and we're definitely not turning a blind eye to that.
I have to just repeat the point that when you speak to victims groups, they are positive in general about Section 28, and I have probed them. Were there concerns? Did they feel like that the victims felt they hadn't told their story, or they didn't feel that they got justice? And we haven't had that feedback. Now, that isn't the final answer on this, but when we speak to victims groups, Section 28 is viewed positively.
Have you fed back at all, Minister, in terms of the pork technology?
I've had some barristers mentioning that, actually, and in the context, the other thing that barristers mention, I want to be fair to them. They say that it's unhelpful when you've got busy Crown Courts to have a day where you have to do all the preparation for the trial, get ready for cross-examination, and then return to the trial much later, that it would be easier in terms of their diaries and managing the case just to do it all in one go. But as I say, that is a different perspective to the victim, who may actually find it really quite powerful to be able to tell their story in a room on their own, and we have to balance all of that. But of course, we're mindful of the fact that the Crown Court has got delays, and we don't want to be throwing grit into the machine unnecessarily.
Thank you. I want to follow up on this around court facilities.
Yeah.
So that we can do select committee hearings by Zoom, and the technology, she says, touching wood, very seldom fails us. So why in 2023, well, let's use 2023. Well, yeah, but it would have been last year, trials last year, we're still early in 24. Were we getting evidence from the University of Nottingham, who are saying that in observation of trials, technology was often not working, it was of poor quality, that transcripts were required of videos because the audio was so poor? Why is more investment not going into decent kit, which, to be quite frank, it oughtn't to be impossible to have an audio recording that is the same quality as you or I would get on our iPhone?
I mean, Chair, if I could just give you one, just from my days in practice, which ended in 2019, you practically couldn't get any video facilities at all in court then. It has progressed a lot, and actually we did well in the budget. We have got a dedicated budget for technical upgrades. We've had meetings about that, where there is a sort of that upgrade process has begun, and actually it kind of began with COVID, where we started remote hearings for the first time, something that would have been unthinkable, unworkable, a complete anathema to all kinds of courts.
How much money is going into investing in the tech?
I'm sorry, I don't have that offhand.
No,
we can get back to you on that, actually, because
perfect.
we have had a meeting, and I am aware that we actually have got a designated budget for it, and we have discussed this very issue, but I'm sorry I don't have the figure.
That's very helpful. I want to, and you yourself, Minister, have pointed out several times that it's female barristers prosecuting and defending this. Now, this committee's done an enormous amount of work on the menopause and had the Bar Council do some round tables with us. And I'm just going to read to you what they then said to us. So this is women barristers, improvements to court estate and facilities, including hygienic and working toilet facilities and temperature control in courtrooms. These improvements affect not only barristers, but also court users, staff, juries, etc. Last time I had to do jury service, it was at Southampton Crown Court. The jury room was like an oven, and we were told that the heating couldn't be turned off until one of my fellow jurors, who was a heating engineer, managed to do it.
God.
I raised this, I think, with the Attorney General, herself a barrister, who told me that she had experienced appalling court facilities that didn't make a conducive working environment to women. So if we have a problem where most of the prosecutors and defenders are women, and most of the court facilities are not conducive for women to be working in it, how can it be any surprise to anybody that female barristers are not wishing to do this work anymore?
Well, that's a very, very good question. We have got a 220 million court upgrade programme that is underway at the moment, and there are definitely courts where there could be improvements, and I think you may have just given a few examples. I don't think women are leaving the profession because of court conditions, but actually there is a problem with attrition at the bar from women, and it is, I mean, this is just stuff that I used to say all the time on the Justice Select Committee. Kirsten and I were on it together, I think, actually. But I mean, this is something where, you know, there is a bit of a problem with diversity, particularly at the top of the bar and in Rasso all the way through. And you've made really good points, actually, which I will feed into whoever is in charge of our court upgrade programme. But I just want to reassure you the funding is there and there is a programme of work. Amy will correct me if I have missed anything.
I don't think so.
No, there is, and actually sensible things like proper aircon and facilities. And also I'd add another one for pregnant barristers, not always having to be on their feet.
And you just said it, there's a problem with diversity at the bar.
There's been an attrition, there's been an attrition issue forever because, we're moving away from violence against women and we're talking about women in a particular sector, but I think that there's equal pay issues at the bar. And there's a problem with attrition. If you don't need to take a minister's word for it, look at any barristers' chambers anywhere in the country and you'll see that at the top of it there's far more male practitioners than there are females, but at the beginning, in the early years, you'll see a diverse bar. That's common.
Institutions like the Garrick being all male impact on that?
Well, I'll give you. I think the reasons are because a lot of it being a barrister involves travelling around the country, and I think often, not all women, of course, have children, but those that do often then decide they don't want that life. It's also you're self-employed, and historically that can be really difficult after you've had maternity leave, so there can be problems with rebuilding your practice. There are probably wiser heads at the Bar Council than me that could say what happens, but it is still very poor to look at different practitioners' chambers and see that, you know, a lot of women aren't there at the top. And the women who make it through onto the Supreme Court, I know there are a couple now, they are still the exception, and that is something where I think the legal profession does lag, maybe even our world, although that's not perfect.
Far from it.
But yes, I take your point, and yes, I agree with exactly what you're saying.
Thank you. So I had an email 2 days ago from a young woman who was assaulted in January 2022, had a trial date set for March 2024, and was informed on Monday that the case had been vacated and it would be a further 9 months until that case can be heard by a jury. So it's going to be 3 years before she has her case heard. What message should we be sending to victims as to how that's going to speed up?
Sorry, and thank you, Chair, because that was also a question from you, Kim, and I didn't answer it. That is a very urgent issue that we're looking at the MOJ, and I just want to make clear, listing is a judicial function, and they are meant to prioritise cases with vulnerable victims. It is always alarming to us to hear about somebody waiting for a rape trial where the case has been postponed, although that is, I have to be clear, that is not within the MOJ's realm of kind of control. I know that the Lord Chancellor has had conversations with the LCJ, the Lady Chief Justice, about this issue. I know that this is something that there's a real focus on. One of the issues is that priority is given to cases with a pre-trial custody profile. In other words, if the defendant is on remand, that case does get prioritised because they've lost their liberty awaiting trial. That isn't always the case with rape cases. Often the defendant is out at large in the community, and I do think that has created some tensions. And when we hear cases where the example you've just given us and other examples we hear, often what has really happened is that there's been a postponement on eve of trial. So actually the police have done their job right, the CPS have done their job right, everybody was set up for trial, and then there was a postponement. Within the absolute limits of what we're able to influence, we are very, very keenly aware of that issue, and we feel its importance, and I wouldn't wish to minimise it, although I must repeat that listing is a judicial function.
Thank you. Kirsten.
Thank you very much, Chair. Minister, you've talked about access to pornographic images, non-consensual intimate images. I'd like to look more at that. So the act of posting a non-consensual intimate image online is illegal, but strangely the act of reposting it, which obviously increases exponentially the reach of the non-consensual images, is not. Do you think that loophole should be closed?
A sharing offence. We have a sharing offence, which we created in the Online Safety Act. So the Online Safety Act, the Intimate Images provisions were commenced on the 31st of January, and the sharing of a non-consensual intimate image is now an offence.
Okay, so you're not concerned in the way I am about this because you think that issue has been resolved.
Well, I would have. That, you know, it's a very good question. I would have understood a repost as a share. If I'm wrong about that, I think I ought to get back to the committee and clarify. But my understanding is that a repost would be a sharing of an image and it would be a further offence. But I will absolutely clarify that.
You heard very clearly from the Revenge Porn Helpline
that a repost was not a share.
Was not a share.
Yeah.
And how quickly, if that is the case, how quickly could anybody in this place move to close that loophole?
There's two questions there.
Sorry, I don't know. I would have to check that. And
Can we check that and come back to you?
I think we would be interested if that is a loophole that needs shutting.
Yeah, so I had focused on the word sharing, and I would have understood a reposting offence to be a sharing offence.
You can perhaps see the concern where if this is indeed the issue that we think it is, and there is a lack of clarity on your part.
I will undertake to take that up for you.
That there will surely be a lack of clarity on others, on other parts too. So it would be good to hear further about that.
I'm really glad you've raised the image stuff, because the commencement of those provisions on the Online Safety Act, the sharing offence, the cyber flashing offence. We got the first person has been sentenced to a custodial sentence yesterday for cyber flashing, and you know that is an offence that had gone under the radar for a very long time, almost like a sort of, you know, just part of being a young woman was to experience that. And we got that onto the statute book, we've got it going, and we're now seeing people and getting custodial sentences as well. And I think that's really important, that this isn't just grubby behaviour. You will feel a severe penalty if you do something like that.
Okay, and that's helpful to hear that progress. You've said, though, that you don't think that enough is being done in general in this space. You said that earlier today. So I wonder what your views are on making non-consensual intimate image content illegal, so that internet service providers are required to block the content and platforms are required to remove it. Do you think that should happen, and is that something you would look at doing?
Yes, and I think this is covered by the Online Safety Act. So we're moving with the criminal justice bill that's going through the House at the moment. We're moving from an intent-based theory of intimate image abuse to a consent-based model. So there will be now a base offence of any intimate image that is taken of a person without their consent is a base offence. The maximum penalty for that is 6 months. If it's on top of that established that the image was taken for the purpose of causing alarm, humiliation or distress, then that's a more serious offence, attracting a maximum custodial penalty of 2 years. Then there's the sharing offences, which are set out in the Online Safety Act, and that the Online Safety Act had to be sort of limited to sharing because it was basically a communications act, and so it needed that act of, and that's where I'm going to come back to you on the retweeting example that you gave, the reposting example that you gave. I do think that the law actually is now pretty robust in intimate image, both non-consensual making offences and sharing offences.
And what about the internet service providers in all of this, though? That's the bit of my question that you didn't answer. So, do you think that internet service providers should be required to block the content and that platforms should be required to remove it? Is that something that the government will look at?
I'm just having a look at, there's an order of priority, isn't there? And I made a note of it before I prepared for this.
I imagine if that was something that had happened to any of us, then that might be a significant priority, because the hosting of such an image on an internet platform where however many more people could look at it would be something that would be of grave concern, I would think.
So the reassurances, and I just distilled the principles on the Online Safety Act. So they have an obligation, their absolute priority is to remove illegal content, and that includes harassment or stalking activity, and we know that a large proportion of stalking takes place online.
That's not what I'm asking.
No, I know. The second thing that the internet service providers have to show is that they have effective systems to take down other unlawful content aimed at women, cyber flashing being an example, intimate image abuse being another example, and the purpose of that was set out in the sort of accompanying notes of the bill was to stop perpetrators using the internet as a weapon. So there's a removal obligation on the internet service providers.
I think that it might be useful to go back to that and to write to us on that as well, if you don't mind me saying so, because I don't think
You don't
with
think
the
it goes
greatest of
far
respect
enough?
that you're answering my question.
Okay.
I think that there's detail that's missing there. So I want to know if the government are going to consider making non-consensual intimate image content illegal, so that internet service providers then are able to be required to block the content and platforms to remove it. And I don't think we've quite got there. But let me move on. Maybe a more theoretical question to you, Minister. Do you think that a registry operating in the same way that the registry for child abuse images might be a suitable mechanism to identify, to classify, and therefore to allow for the removal of non-consensual intimate images?
I think that's a really good idea.
Okay, thank you. I'm going to move on to a final topic and look at abortion safe zones in England and Wales. And I wonder if you think it would be fair to say that the UK government is trying to water down the Public Order Act by allowing silent prayer within abortion buffer zones in the draft non-statutory guidance.
I was somebody who voted for that legislation. But I do think that you engage you've engaged competing rights under the Human Rights Act. I mean, there's freedom of expression, and silent prayer is obviously going to be a particularly difficult category because the proportionality exercise requires you to ask how far that encroaches on another person's freedom. So I don't think the government is trying to water it down. I think it's trying to judge where the line falls between competing rights and obligations, and I think that silent prayer is a difficult category on that. I actually should make clear, though, I don't speak for the government on this because abortion issues are a free conscience matter, and that shouldn't be conflated. But I do have a bit of a background in human rights law, and I do understand that sometimes it's easy to say, well, I don't like this, but actually when you look at the Human Rights Act, they can pray in aid of a different provision under that, and there is a balancing line. There is a fine line to be drawn.
I mean, obviously, I am asking about it in the context of the Public Order Act, so I think it's a reasonable line of inquiry.
Yes,
but
no,
I think
of
you're
course.
basically saying no. You don't
saying
think
no.
it's been watered down.
Look, I'm
So
speaking more on a personal level, but
sure.
I think it engages quite a difficult issue. I think it is right on the edge. And that's quite often the case where human rights questions become difficult, that both sides have got a reasonable claim. I think you're in that space for this. But I don't think the government is trying to water it down, and the government doesn't really have a view on abortion. And in any political party, you'll have politicians with different views, and that's kind of respected.
Nobody will disagree that there'll be a range of views, but specifically looking at the Public Order Act, you don't think that there's an aim to water it down. So does that mean that you disagree with the Equality and Human Rights Commission's observation that paragraph 2.7 of the non-statutory guidance could be wrongly understood to be providing an exemption for silent prayer, which is obviously a different angle?
Can you read me that paragraph?
No.
Oh, okay. Well, I'm not sure what paragraph 2.7 says.
Do you think that there is...
If I could just see, because I know the Equality and Human Rights Commission well, I'm not unfamiliar with their work. I'd just like to see how they phrase it, and I'd like to consider it in that context.
Do you think that, putting the specifics of the wording aside, I think that the principle of the question remains. Do you think that there is a potential misunderstanding that there's an exemption being cut out for silent prayer?
This hasn't really been drawn to my attention, and I would need to consider it, and I will revert to the committee on this if this is an outstanding concern. Okay. I think the purpose of the legislation, I remember being in the debate for it, was that some people were being barracked on their way to seeking lawful and safe abortion services. And I remember, I think it was the member for Ealing who brought it forward, and I remember how she presented it, and it was about stopping women from being sort of as I say, barracked on their way in. And I was, I think lots of members understood it and supported it on that basis.
So can I...
At the very margins of people sort of standing in silence, you can't stop abortion being a controversial issue where people will have competing views. I don't know enough about this, and I don't know what paragraph 2.7
I'm just trying to get
says.
to the facts of the issues that I'm raising, rather than going into the variety of opinions, which I think we would all agree are there. Can you confirm to me, though, that all protests, including silent prayer, will be banned in abortion buffer zones?
I honestly don't know where silent prayer falls on this. I can't immediately see that somebody standing silently with their eyes closed in prayer would amount to an offence under the Public Order Act, but I could be completely incorrect about that because I haven't read the Act and I don't know what the Equality and Human Rights Commission said.
Final point from me then. When do you can you tell us when the legislation passed by Parliament
Will
last year
commenced.
will be implemented?
Yes, that's a good question. Do we know?
Sorry, not on abortion.
We can
So
get an
maybe if
answer
you
on
can
that.
write
I mean,
it.
we can get
That'd
an
be
answer on
helpful.
that.
Thank you very much. Thank you, Chair.
Can I just say that I'm going to follow up on this because you might expect me to, having both spoken in that debate and voted in favour of the legislation. I was very clear that it was Parliament's will that women accessing lawful healthcare should be protected from harassment. And whilst I can see there are competing human rights issues at stake here, if the Home Office is going to take the view that silent prayer is not harassing women accessing lawful healthcare, at what point does too many people engaging in silent prayer harassment?
Well, I don't know exactly what the Equality and Human Rights Commission said on this, but you're right. These are you're going to be at the margins with things like this because there will be a legitimate argument around freedom of religious belief, freedom of expression, which isn't interfering with anybody else's right to get an abortion, and then the example that you've chosen, which could become, obviously, to cross a line. There are difficult cases in this area of the law, any equivalent area of the law, which will sit at the margin, and I'm happy to take back to the Home Office how we're going to define where that boundary falls. But it isn't wrong or inappropriate that competing considerations that are fundamental are weighed in the balance when preparing guidance. And as I say, the Home Office isn't thwarting this issue at all, and nor does the government have a position. Its role is to faithfully implement.
The role of government is, in this instance, when that was a meaningful vote in Parliament, the role of government, surely, the role of the Home Office is to implement the will of Parliament.
No, look, you're asking a question which I concede falls close to the boundary. And I will have a look at that and see. I will particularly consider what the Equality and Human Rights Commission said. I'll come back to you on that point. And I don't think I can give a better answer than that.
No,
at this
I
point.
think
On legislation that hasn't yet been commenced.
Yeah,
and
absolutely.
I think it's fair
And
to sort of... you're right, you're raising hypotheticals, but it's reasonable that you do. And
I don't
it's
think we
fair
are
that
raising hypotheticals. Parliament's will was that there should be buffer zones to protect women accessing lawful healthcare.
Yeah.
And from the perspective of certainly part of this committee, it feels like there is a dragging of feet. It feels like there is some wriggling away from the protections that Parliament wanted to put in place. And I think it is only fair that this committee puts down a very firm marker.
It's a fair question.
That it was the will of Parliament that women should be protected from harassment when they are trying to access what is perfectly lawful healthcare. And if silent prayer is to be permitted, I think this committee would be very interested to know how many people praying silently is too many.
I will get back to you.
Thank you. There were a number of issues, I think, that you're going to get back to us on.
We have a note of them.
Yes, there are some officials busily noting everything behind you. Can I thank all three of you for your evidence? I'm conscious that the Minister has been put very much in the hot seat herself, but that is as it should be. If there is anything else that you would like to add afterwards in writing, then please do feel free to do so. But I will bring the meeting to a close and thank you for your evidence. Order.
Thank you.
The proceeding has ended. 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 The proceeding has ended.